So that's what was missing. I forgot to put music in there. Next time I'm going to add some music to the countdown because that was not fun. Hey, here's something that should scare landlords. There are landlords losing eviction cases right now, not because they did anything wrong with the renter or paperwork, but because they didn't pay the interest on the security deposit, a tiny detail, a line item, and a case lost. That's California landlord-tenant law in 2026. The devil's in the details. Welcome to Real Estate Disclosure, where we have the conversations nobody else is. This is episode 1 with the new name. We've got over 50 live streams, and a lot of them with California Property Law Group. We decided to give it a name. We got the same mission. We're having strategic conversations for residential portfolio owners. You can't afford to miss this stuff. Can't afford to get this wrong. And who better for our inaugural episode than our buddies at California Property Law Group? We've got Kenny here. Kenny, I'm going to bring you in a second. Don't worry. So we got security deposits on the menu tonight, what's required, how technicality can sink an eviction that you should have won. We're going to talk about a proposal in LA County that was shut down. It didn't pass, but it would have required 3 months of back rent before you could file an unlawful detainer. Still important to know where the zeitgeist is headed. And then this is a big one at the national level, the proof of citizenship requirements for renters. We're going to talk about that. That's not required as of right now, but I want to talk to Kenny about that and get his opinion as an eviction attorney, his thoughts. And let's also discuss the unique challenges of larger portfolios. So when you got 1 or 2 rental units, like a lot of folks out there do, that's one thing. But when you have multiple units, the rules aren't written for you, and the mistakes can often be bigger and much more expensive. And that's even if you have a property manager. So we got Michelle on chat. I'm a broker, not an attorney, but the guy in ties, well, it's just one guy. It's Kenny. Get in here, Kenny. There he is. Kenny, welcome.
Hey,
congrats. You made the cut for the first Real Estate Disclosure episode. Congrats.
Yeah, thanks. I like the name. I think it's pretty suiting for what we do here.
Well, that's exactly, because disclosure goes many ways. And at the end of the day, disclose. Okay, so I'm excited. Let's dive in. Not going to waste any time. Kenny, what are you seeing in courtrooms right now? AB 2347 is over a year old. That's one of the things that changed. And that basically took it from 5 court days to 10 court days for a renter to respond to an unlawful detainer. So touch on that and then tell me what you're seeing, bud.
Yeah, so in courts, what's actually happening, which is a weird side effect to Measure ULA, specifically in LA City, because Measure ULA really just dealt with LA City. You're seeing a lot more tenant defense attorneys taking cases on and quite frankly, being a lot more aggressive in how they litigate the cases out. And what I mean by that is that they're not willing to actually look at the actual merits of what's going on. They are looking specifically at the procedural defects that some landlords might walk into. And what they're also doing with the funds from Measure ULA is that they're trying to prop up, or I guess put up more rent relief programs, which on its face is a great thing, right? It's like, hey, we're trying to create a system where we're keeping people housed and also pay the rent for people. The thing of it is that it creates perverse incentives when it comes to evictions, because what I'm seeing is that there's a lot of tenant defense attorneys who are now being funded by this program coming to court and saying, your case sucks, you messed up on X, Y, or Z, even if they
Give
don't.
Me an example. Give me a procedural defect example that they're catching for other attorneys, not you.
Yeah, so they're saying that because you can't prove that you filed it within 3 business days, you're going to lose the case. And it's like, okay, you just haven't seen our paperwork that we did. Here it is. And they're still saying, okay, well, I want you to accept this rent relief program. Now, the thing of it is great. I love it. Let's do the rent relief program. But in the meantime, they're refusing to actually stipulate to anything or to agree on a date where this would end. Now, just like any other bureaucratic agency, what you're running into is these rent relief programs might take 2, 3, 4 months to resolve themselves. And the worst case scenario is it takes them 4 months to say, we don't have the money or you got denied. Now, where does that
Mm,
leave the eviction case? Well, you
yeah.
wasted 4 months of everyone's time. And at that point, the defense counsel just raises their hand up and says, well, what do you want to do? You want to do trial? Well, that's what I've been wanting to do. I've been wanting to do a trial over this for the past 4 months. But obviously, sometimes the rental money, if it gets paid out, that's better than the trial. So we're trying this avenue out. But because it's such a chaotic mess with which city is running the program, which county is running the program, where's the money coming from, who has priority, who doesn't have priority, um, it just creates kind of a jumbled mess where every single defense attorney is now coming to court and saying, do rent relief, do rent relief, do rent relief, because that's the script they're being given from, uh, well, the county as well as from the city, saying that, we're using these taxpayer dollars to try to get people to take rent relief. And, the heart of it is, I agree, it's, the incentive and the heart is there, but it creates perverse results where things aren't getting resolved because everyone is waiting for a program that may or may not happen.
That's an excellent point. We're right back to where we were during COVID with the poorly managed funds that were handed out for tenants who were behind. And let's further expound on this. So you've got in LA City, you have to wait until a renter's behind 2 months worth of rent before you can file the unlawful detainer. And in some cases, it's longer because it's based on fair market rent. So if your rent is below fair market rent for your bedroom count, it could take you 3 months to get there. Then you've got to wait 10 days to hear the response after that's filed. Then, like you said, there's a plea to accept the rental assistance, and another 2, 3, 4 months. So now we're getting into a 6-month process, and that's before we even talk about an unlawful detainer that's successful and getting a sheriff lockout. That's an interesting change in the process. And then the other thing you mentioned, the stipulation. So to further expound on that and clarify, so the stipulation is like a written agreement in court that the two sides come together and they say, okay, we're going to give you this amount of money, we're going to give you this amount of time, etc. And it's all signed. And if both sides don't live up to the stipulation, if one side doesn't live up to the stipulation, it's voided. Am I correct? And that's what you're missing right now.
Well, so a couple of things.
Sure.
The stipulation is just like an agreement, but the reason why we call it a stipulation would be that it's in front of the court, and it's generally going to be a stipulation for some kind of an order or a judgment, usually. And that's the reason why you file lawsuits, because when you get a stipulation for a judgment, it's different than, if you go out on the street and you talk to people and you say, do you want to pay me X amount of dollars to rent this place out? That's a contract. You have an agreement. It's the same thing as a stipulation, but it doesn't hold the same importance as it would if you were to stipulate it for a judgment, because it no longer becomes a contract. It's something more. It's something more powerful, because
Mm.
you're able to then take it to court and say, this is what we agreed to. We're not going to have a trial over this. We're just going to have you, the judge, decide if this was breached, and then we get a judgment that can be enforced immediately, or depending on what the terms of the stipulation is. There's many times where people ask, or my clients ask, well, why can we come to this agreement outside of court? And that's because you can't get a stipulated judgment that way. And the
Got it.
stipulated judgment is the most important thing, because you don't want to have to fight it out in front of a trial with a jury, where jurors can do wild things. We had a case one time where a couple of jurors didn't understand that the defendants, just because they're in jail, that meant that they're not renting the unit out. And they said they don't live there anymore. They're in jail. So essentially, one of the elements for an eviction is that you have to prove that they are renting the unit, or that they have right to possession. And the jurors, when they heard that the defendants were in jail, they said, well, they don't live there, so no, they don't rent the unit out. So jurors can do, anything that they're going to do. So trials can be very risky in that sense, but with stipulations for judgment, that's guarantee, that's certainty, and that's what everybody can react to, because certainty guides your decisions. And to a certain degree, that's kind of the reason why I think that when it comes to what the city is doing and what the county is doing with threshold limits, it doesn't give certainty. because the rules can change, 6 months from now, a year from now, even with these rent relief programs. Who qualifies, who doesn't. This can all just change off the whim of our elected officials. And I do want to point out that LA City, the threshold limit still is 1 month, but because of what LA County is doing, they're considering raising that threshold limit. LA County is actually looking to actually push forward with the resolution that's going to raise the threshold limit, which is the amount of rent the tenant has to be behind before you can file an eviction, to 2 months. They thought that 3 months was a little bit too far.
Yeah.
They wanted 3 months, but now they're doing 2 months. And that's probably going to pass in the next couple of weeks or so. So now, if your tenant is behind 1 month of rent, well, wait another month and see what happens. But leaving that aside, it's not even just 1 month. What happens if your unit is rented at below market rent?
Yeah.
Well, let's say that you're renting only a 3 bedroom for 1,000 because you thought, I'm giving you a great deal because I just want to, be a nice landlord or just be a normal human being. Well, now you have to wait not 2 months, but maybe 4 or 5, 6 months to meet that threshold.
Yeah.
So this is the unanticipated or the unforeseen kind of consequences of what they're doing by raising this threshold limit. They're inadvertently hurting landlords who are renting out below market units, which is what they want.
Yeah. And again, the reason for that, and I misspoke when I said it was 2 months, I was doing the math based on the thresholds. So the thresholds are based on a fair market rent. So LA City has their renter protection notice and it's stipulated on there, but it's based on bedroom count and fair market rent. So like Kenny said, you may have a unit that's well below those thresholds on there, and it's going to take you even longer to catch up. And I'm glad you segued into that, because I did want to talk about LA County and the 3 months rent that they were trying to pass. But it sounds like now they're asking for 2 month threshold, which again will be based on fair market values, which means that if you're below market, it's not just 2 months, it could be 3, 4, or more before you can move forward with the unlawful detainer. And the justification for the 3 months, I guess, was related to the fires. I mean, I can't remember what the justification was this time.
No,
What
it was
was it?
actually in relation towards the Trump ICE raids.
That's
So
right.
they
That's
were
right.
saying that essentially there are individuals, and I understand that there are individuals who unfortunately can't work because of what's going on in our national political
Yeah.
sphere right now.
Yeah.
Um, but the thing is, what the LA County Board of Supervisors don't realize is that it affects everybody equally.
Yeah.
We had a case where our witnesses, this is a landlord who said, "Hey, my tenant is creating a nuisance on the property." However, the people that saw that don't want to come to court. And I said, "Why? Are they scared of the tenant? Are they scared that the tenant might do something to them?" And they said, "No, the ICE raids."
Mm.
And I was like, "Oh, so this ICE rate affects everybody equally. It's not as if it's a landlord-tenant kind of situation." But for some reason, the LA County Board of Supervisors is using it in a way to say it disproportionately affects the tenants. And again, I have a real example where I'm having trouble with some of our witnesses who have to come to court to testify, and they don't want to because of these ICE raids. And the ICE raids, leaving aside the political nature behind that, it's an unfortunate reality that we have to live through nowadays on that issue.
Yeah.
But to use that to then put more burden on the landlords in terms of how much they have to shoulder for the financial costs, I don't know if that achieves the actual goal that the Board of Supervisors is actually looking to achieve with affordable housing.
No, it's a complete opposite, where it just drives out more and more landlords. More and more landlords get fed up and say, "That's it. I'm not going to rent out my unit." It's crazy to me, but there's people who say, "I'm going to keep these vacant," which it's no longer an income property if it's not generating income, but they feel that's safer, or they sell and they get out of town. And we're seeing cap rates go up and values drop all throughout LA, and it's due to these policies. And nobody feels bad for the landlords if they're losing money on the sale of the property, but that also leads to fewer landlords who are going to want to take care of the property. So let's talk about again what you were just discussing about ICE raids, and let's talk about the discussion. And we'll obviously keep it as neutral politically as possible, but the discussion of requiring some sort of citizenship check for landlords on new tenants and then potentially existing tenants. Any thoughts on that? How that's going to play out as an eviction
So
attorney?
yeah, so I mean, just as much as anything else, like I said before, generally you want to be predictable on what a business is going to have to comply with. These laws that require, and it's going to be discussed on a national level, not on a local level for these ID checks. But if there is going to have to be this check where you have to see the status of individuals that you're renting out to, it's just going to be another burden, another cost that landlords are going to have to potentially either eat or pass on down to the tenant at this point. And it's just not something that I think is going to be sustainable for actually keeping rents low or even housing costs low. Um, you know, I think I've said this before. The way that you kind of get to where you want to get to is that you just have to build more housing, and that's kind of what you have to
100%.
do. Adding more kind of disclosure requirements. I mean, California already, it's like we're disclosure heavy, um, in any field. If you ever go down, I mean, take a look at your local fast food joints, right? When it comes to employment laws, right? You go see behind any of the cashiers, there's a wall of text. There's just a wall of it's just disclosures. They're trying to treat landlord-tenant law the exact same now. With the notices, we have to give out 10 different disclosures just to be compliant. And if you don't do that, you lose the case.
Yeah.
And the thing is, to a certain degree, Trump had a policy that I don't know if he's kept to it or not. But his idea was for every regulation you add, you remove two. There's some merit behind that, where it's like some of the stuff that you add on just gets added on endlessly. I mean, even if you take a look at lease agreements, how many documents do you have to sign? How many pages of documents are you looking at with all these disclosures, and saying, well, you signed it, you knew it, it was disclosed to you.
Yeah.
In reality, the protection that it's trying to give you is not really the protection that it's meant to give you, because not everybody reads those disclosures. But California is a very just wants you to disclose, and then that will safeguard you. But ultimately, at the end of the day, I think what people are looking at is rising rents, rising housing costs. And I think that the LA County Board of Supervisors is taking somewhat of a hard stance on a position that I don't think is going to get them to the result they want.
Yeah, it's very similar in LA City, where they removed the ability to do a substantial remodel under their just cause ordinance. And the what's was crazy to me about that was that there's so many hoops you had to jump through in order to do it. You had to pull all the permits ahead of time and deliver those to the renter, and you had to have special language in there, et cetera. And they took that away. And what's interesting in LA City is they do track the evictions that are going on in the notices of termination of tenancy. And there were fewer than 100 of those across all of LA City. But there were 50,000 and that's not a number I'm exaggerating. That's not it's a legitimate number, over 50,000 evictions due to non-payment of rent. So they took away the rights of property owners in LA City in order to, because so many people were supposedly being kicked out when it was fewer than 100, which is, don't get me wrong, it's still sad that 100 people are being kicked out, but doing nothing for the other 50,000. Now, these funds that you mentioned, the Measure ULA mansion tax funds, this is the attempt now to help those other 50,000 by providing attorneys and the rental assistance. But we'll see, as you're already describing there, it's not an effective rollout. Let's dive into this question. I think this is a good one.
Really
Go
quick
ahead,
question, if
Kenny.
I could just make one comment.
Sure.
I mean, the writing is on the wall. It's only going to get more restrictive, and you're
Yeah.
seeing this in the past, 5, 6, 7 years from now. So if you're looking to own property in California, you need to treat it like a business at this point, or you are going to get demolished. There's just no way around it.
Yeah.
Because the thing of it is, I mean, you could see it even in the ballot initiatives, right? I mean, it was only 2 years ago, Prop 33, where they were trying to repeal the Costa-Hawkins Act,
Yeah.
right? And then right after that failed, there was a bill that the legislature was trying to pass that said, you know what, there's an exemption for single family homes, probably one of the most valued types of real estate that now exists in our country, and they're saying most of those properties are exempt from these just cause protections. What happens if we remove them? What happens if we actually just subject them to these controls now?
Yeah.
That did not pass, but the fact that they're talking about it
Yeah.
means that that's the way we're moving towards. And again, LA City is closely watching what LA County is doing, and I'm telling you, this threshold limit, it's not going to stay. It's going to go up. LA City is going to follow suit.
Well, and the threshold limit too, the other thing, and it actually it motivates tenants to have a running balance they owe. They basically, if the threshold is 1 or 2 months rent, you don't pay 1 month and you just keep it rolling. There's no incentive.
You could be a
So
credit card company now.
yeah, the landlord becomes
0% interest.
Exactly. And then real fast, talking about the single family homes and removing those protections. So according to John Burns, who tracks housing market data, 80% of single family homes are owned by mom and pop landlords, which is those who own between 1 and 10 rental properties that are single family homes. So 80% of those, so everybody's saying, oh, we want to, the big corporations, we don't want them to have the rights. Well, under the Tenant Protection Act in the state of California, big corporations are not exempt from the Tenant Protection Act. So their properties are subject to the restrictions, number one. And then number two, you're hurting 80% of mom and pop owners out there when you start to pass legislation related to single family homes. Okay, get off our soapbox for a minute and we'll come back. So this dovetails into what we were talking about with requiring a proof of citizenship and kind of anticipating what that's going to look like. So this particular person had a situation where the applicant did not have a social security number. If a landlord rejects the tenant based on that, would that be considered discrimination? What are your thoughts, Kenny? Because that's is having a social security number, does that fall under fair housing?
No, so it's going to be dependent on what the new law says in regards to the types of classes you can discriminate against. So, to kind of maybe give a very short legal lecture a little bit, at a base level, everybody kind of discriminates, right? Where if basically I'm looking at an individual and I say, well, I'm not going to rent out to somebody that can't afford the unit. Well, you're discriminating against people that can't rent out or afford that unit, which makes sense. Most people understand that.
Yeah.
Now, the thing is that there's laws that say you can't discriminate against protected classes or specific kinds of categorizations. So everyone understands the normal one where it says, I'm not renting out to you because of your skin color. Everyone on its face understands you can't do that. You don't need an explanation. Perfectly fine. Now, it'll just depend on the social security number whether or not they pass a law that says that. So once that goes on the books, or if it ever does, then obviously you can't do that. As of right now, I'm not familiar with whether or not that's a requirement. I can't say for sure at this point. I don't believe there is.
There's one case where you get yourself in trouble, and then one of our other people watching, they asked, can you do a credit check without a social security number? So the one caveat in this, and Kenny, you tell me when I'm screwing up, but under Section 8, you are not allowed to discriminate if they have essentially low credit on some level. The folks on Section 8 are able to use alternative methods to prove that they're able to make payments on time, which includes showing gas and electric bills, for example. So I could see a case where you just have to be careful, particularly with Section 8, if they say, and I don't know if you need a social security number for Section 8. I don't know. I don't think you do, but if you you could see there where you could get yourself in trouble. If somebody's Section 8 doesn't have a social security number, you can't run a background check because they don't have a social security number. That could be your justification for saying, no, I can't do a background check on you, so no. But if they can prove it another way with utility bills, that would be where you'd get in trouble. Does that make sense, what I was saying?
Yeah. So I mean, with Section 8, you run into issues of source of income discrimination. So that's
Correct.
protected under California law. So you
Yeah.
can't sit there and say, I'm not renting out to you because I don't like where your money's coming from.
Yeah.
Now, obviously, if it's coming from an illegal source, absolutely, you could say, I'm not going to partake in this. Like if he's like, well, I'm a huge drug lord that, I'm in Mexico and I'm a huge drug lord. It's like, okay, well, I'm not going to rent out to you. That's fine. But if they're coming to you and saying, do you take Section 8? You cannot say no. You're going to get hit with a lawsuit over that.
Correct. I've talked to several folks that's happened to.
Yeah.
There's attorneys out there that are sitting by the phone, having tenants call and putting together big lawsuits. So.
Yeah, and in relation to Section 8, the issue with Section 8 realistically is it's a federally run program. And the thing is, they have guidelines with HUD that will tell them generally how to run the program across the states. And within the states, not every state has the same laws. And the reason why I'm bringing this up is because I've seen situations where the HUD advisor raised the rent on the tenant and said, don't worry though, the tenant's portion is not going up, just the overall rent is going up.
Yeah.
Now, LA County did not like that because that rent increase violated the local rent limit jurisdiction.
Correct.
And the thing is, the landlord didn't know that it was a violation. The tenant didn't know. The HUD advisor didn't know. Nobody knew. 3 years down the road, LA County comes knocking on the door and says, refund all the money back. Well, who are you refunding the money to? Are you refunding the government the money back? Are you refunding the landlord the money back? The government's the one that paid it. No one had a bill increase except the taxpayer. Now you're seeing litigation filed over it because the LADCBA or LA County Board believes that money should be paid back to the tenant. And I don't know where they're going to go with that, but it's a waste of resources if you really think about it.
Yeah.
Because again, the Section 8 advisor, the HUD advisor, just didn't know what the local laws said. And that's kind of the issue with Section 8. So you have to be very careful when you're taking Section 8 or dealing with Section 8. And just to tie it in a little bit more with what we were talking about, the threshold limit, talk about a situation where you want a non-payment of rent case with threshold limits.
Oh boy.
Well, let's say that the tenant's portion is $200 for a 3-bedroom and Section 8 is subsidizing 90% of it. And the rest. So Section 8 is, let's say, paying like $2,500 or $2,800 of it. Well, you're going to have to wait to see if the tenant is going to be behind the fair market threshold limit at a rate of $200 a month for a 3-bedroom. Now, there's another fun little tidbit where you can't evict somebody for non-payment of rent for anything that's older than 12 months. Well, if we do the quick math,
you'll
12
never get
times
there.
200 is only 1,200 or 2,400.
Yeah.
So you'll never reach that threshold limit. So the tenant can just sit there and say, well, I'm never paying you my portion. Section 8 will pay their portion, but you'll never receive my portion.
Way to go, Kenny. You just gave everybody a tip to stop paying their portion of Section 8.
I'm trying to plead to our legislatures to think about what they're doing.
Yeah.
That's what it is.
And to dovetail into what Kenny was saying, so if there's local rent control, so if you're under the RSO and your rent annual rent increase is 3%, for example, and they're on Section 8, it doesn't matter that Section 8, that HUD's paying the majority of the rent, it's 3% of that total rent amount, not what that person's paying. And I talked to a property owner in by the stadium that basically she didn't raise rents much at all over the years. Everybody's Section 8. She's got like $800 for 2 bedrooms, and she's never going to be able to catch up because even though Section 8 would be willing to pay her market rent, the market rent may be $3,000 for her units, but she can't catch up. So. Okay, let's get through some of the questions. So Yada Tada is asking about a new judge at Stanley Musk, and Kenny's not going to say anything about judges. We don't talk about judges on here. I'm sure they're all great.
Well, judges will go through rotations. So, there's, to my understanding, there's one, two, three, four, five or no, six eviction courtrooms in downtown, and the judges get assignments and they'll go through rotations. So, seeing a new judge in one of those departments, it's not uncommon.
Yeah.
It happens pretty often.
Okay, so here's a good question. This is eviction scheduled for nuisance for next week. The address is incorrect on the notice that the process server delivered. So it doesn't have the unit number. So they're using the example, it's 123 Main Street, but it doesn't have the apartment number. So what are your thoughts, Kenny? Is this, I mean, the notice, is it completely bad? Should they chance it or refile or? And it says it was a
So,
60-day notice. Why are you giving a 60-day notice for nuisance? But Kenny,
yeah,
jump in.
that's another issue. But anytime that you have the notice having the wrong address, you want to redo it. Not only because you're going to run into issues with litigating out the case itself. So let's say that the tenant says, "Well, I don't live there. I live at a different place because you had the address wrong." That's a problem. That's a huge problem. Not only for the case itself, but ultimately for you to get possession back. And what I mean by that is the ultimate final boss is not the opposing side. It's the sheriff. And the sheriff is going to look at you and say, I'm only going to listen to the paperwork exactly as listed. And if your address is wrong, guess what? I'm going to go to that wrong address. And if it doesn't exist, I'm moving on to my next assignment. So, or if that person isn't at that exact address, I'm not evicting anybody. So if the address is wrong, even if it's very small, even if it's off by a little bit, you're going to have to either amend it or start the case over because the final boss, the sheriff, is not going to do you any favors.
That's great insight. And then a 60-day notice for nuisance is not a good idea either, right? That should be first talk to you whether to determine whether it's a true nuisance, and then file. Then it'll be a 3-day cure or quit, and then
Yeah, it's normally a 3-day. Weirdly enough, the protections that are provided set a floor. So if you feel like it, you could serve a 120-day eviction quit notice. But at that point, why are you even doing that?
doesn't
Um,
doesn't
so
seem like a major nuisance if you're giving them too much extra time. Yeah,
yeah, that actually might be something that pegs against you on the
yeah,
trial if you do, because
I'd
it's
bring it
what's the
up.
exigency? What's the
Yeah, didn't
what's the
seem
real
all that
nuisance here?
urgent. All right, some more questions. These are good. These are good. And we're not making fun of anybody here. Don't take it like that at all. We're trying to give you the best advice. So this is one that actually, Kenny, you had mentioned, and I liked your perspective on this. So is it true that for a month-to-month rental agreement, so this is a renter whose month-to-month or lease is ended, that it essentially renews every month? So the new appliance statute, which is basically says as of the first of this year, landlords must provide a working fridge and a working stove that's incorporated into the habitability code. So does that mean that basically January 1st, everybody who is month to month, whether any paperwork was sent, everybody's now under that? All renters and landlords are under that, correct? What are your thoughts?
Yeah, so the take is that whenever it renews on a month to month, whenever you accept a rental payment, or if you change the terms, it's going to be a renewal. Basically, you're saying, hey, look, you're staying in this period on a month to month basis. I don't know if you're going to leave today, tomorrow, next week, or next month, but now that you're paying this new rent, it's extended for that new period. My take on that would be to be on the safe side of what this says. I would try to be in compliance with what the latest law requires for the most harsh leaning interpretation of it, which would be comply with the law and get the appliance for the tenant at that point.
Yeah, and a lot of questions about, hey, is it fine if I just put in a mini fridge? My advice, and Kenny, I want you to give us yours, would be like for like. So whatever's there right now, if it was yours, landlords, put in one that's similar. And also be realistic. Like if it's built for a regular size fridge, the idea of plugging in a mini fridge into that hole, to me, doesn't seem in good faith. What are your thoughts, Kenny? Because it doesn't
Yeah.
stipulate how
So
big or where or what it needs to be.
Yeah, so the thing of it is that the way that I would view it is that if you're comfortable going in front of either a judge or a jury and saying, "Well, I thought that a mini fridge would work out," when most people when they talk about refrigerators for purposes of a kitchen or a workable oven or a stove, I thought that a hot plate would work out. If you're comfortable saying that in front of a judge, um, go for it. But the thing of it is that most of the time you're not going to win that argument. If you have to be a little bit shameful about the position you're taking, there's a reason why you're being a little bit shameful about that position. So the safest route is to just go forward with what the general use of the term would mean for a refrigerator, which would mean a regular standing refrigerator for the unit itself.
Yeah, I appreciate that. And of course, it'll be litigated and everybody will duke it out. So, Yada Tada has another good question here. If a landlord takes the most competitive applicant versus the first qualified applicant, how would a renter go about proving that? So, this is based on a law change last year related to screening renters and paying back the application fee. So, there's two ways to do it. So landlords essentially have to refund the application fees for renters they don't pick. And that's even if the renter pays it to Zillow or Rent Spree, which we use, the landlord has to pay that money even though they didn't receive that money. So there's two ways under the law that a landlord can screen applicants. One is basically pick the first qualified applicant. So the first one who meets your qualifications, that's the one you go with. So if you process them as they come in, if you got 3 and number 2 meets all your qualifications, you go ahead and take number 2. And then in that case, you wouldn't owe money to anybody necessarily if they don't meet your requirements. Then the other way to do it is collect a whole bunch of them, and then you would pick the one you want, but in that case, you have to pay the money back to those that you don't pick. What we do is a hybrid. So we actually have people fill out the application, send in all their proof of income, bank statements, pay stubs, pictures of pets, send us a screenshot of if they have their credit score, let the landlord choose which one, and we give them screening requirements as well. And then they are provisionally approved. And then from there, once provisionally approved, you run their credit through Rent Spree and make sure everything matches up. But going back to Yada Tada's question is, how does somebody prove that you actually are following the law and that you're picking the first qualified applicant? So
Sure. Yeah. So, and I think to a certain degree, in another life, I would have done some kind of tax law because I actually kind of do like seeing kind of the way that the IRS kind of does audits.
yeah,
Um, the burden of proof actually lies with you. When you get it scrutinized, they're not going to be like, "Oh, we have to prove that you did something wrong." It's prove to us that you did it right. Whether or not you agree with that or not, that's kind of the way it is. And the way that I would do it is if you have a system, or and this is the reason why I've been preaching or I've been saying that you need to be treating it like a business, where if you're able to say every single applicant, I don't view them any other way because I have a systematic way in my approach in how I do this. So if you say I look at the applicants that come first serve, and I look at each one until the one that hits all my criteria are met, and then I pick the most qualified one, and I can show you that I do that on all of the units that I've ever rented out, or this is how I do the procedure, and I could spell out to you A to Z that procedure that entire way. That's going to safeguard you more than anything else, instead of you kind of constantly doing ad hoc kind of situations where you're saying, well, I don't really have a system. I saw this guy third and I thought he was first, and it's all haphazard. That's going to cause you more problems. So as long as you can systematically tell me, or tell the inspector or whoever it is that is coming knocking on your door, saying, I treat everybody the same way because I have a system that tells me, I look at the first one here. Do they meet X, Y, and Z? No, move to the second guy. Do they meet X, Y, and Z? No, move on to the third guy. Do they qualify X, Y, and Z? Yes. Okay, cool. I'm going to pick the most qualified tenant, and then I'm going to return the application fee for the other two that I looked at, or anyone else that I have rejected at that point, moving forward. But again, the biggest safeguard is, again, you have to be able to show that this is not something that you just do randomly, but that you have a system showing that this is the way that you treat every single applicant, regardless of who it is.
Yeah, and also, so you mentioned filtering based on X, Y, and Z. X, Y, and Z is income, it's credit score, it's rental history. It is not vibe, and it is not your gut. And I'm specifically calling out a client of mine who's a friend this week. I very rarely rent out units anymore, but I was doing it as a favor. And we had about 30 people come through this open house, and we have 6 sets of applications. And you bet your sweet Bippy I've got everything documented and a system for it. But he was asking me, well, how was the vibe of the renters? And he should know better. But I told him there's no vibe. It's objective. It's highest credit score, highest income, best rental verification history. That's what it is. And the other criteria you can use is who's going to move in first. Assuming everything else is equal, who's going to take possession first is another criteria. So anyway,
Yeah,
sorry, I had to share that.
vibe-based checks are generally not advised.
No.
It's going to backfire on you because the vibes can change.
Yeah, exactly. Be very careful. Your gut, and I've had people call in and tell me they have an amazing gut when it comes to renters, and you could be right, but you absolutely cannot use your gut. That is not going to stand up if you tell a judge that's why you picked them.
The
So let's,
problem, really quickly,
yeah,
the problem with that is that because the landscape has changed so dramatically in the past 10 years or so, you're seeing people ask for concessions that they never would have asked for previously. The unfortunate reality is that cash for keys and waiver of rent has generally been something that has been reserved for cases that you don't want to have to hire an attorney, go through an eviction process, pay that attorney to do all the work, do a jury trial over, and avoid that mess. Nowadays, there are situations where that is the baseline. It's no longer this idea of saying, yeah, I know I owe the rent, but the waiver is already assumed. That's the starting position for some people now. And I'm seeing a lot of defense attorneys telling their clients, oh, that like, because some of the tenants are saying, well, I'm worried about the money I owe, or I'm worried about my record. And these defense attorneys who are being paid by the city or the county are telling them, oh, that's baseline. That's not even something that's negotiated. The negotiated amount or the negotiation is going to actually just go towards, are you getting paid to leave or not? And that's the direction that we're going in. And that's the unfortunate reality that these eviction laws have kind of created.
no, and that insight is spectacular. That's what's going on when you're dealing with this day after day, like Kenny and the California Property Law Group team is. And by the way, if you haven't picked it up, like, you got to hire these guys. It is way too complicated of a process to be doing it yourself. Camtoy, we're coming back to Camtoy. So Camtoy it was an incorrect address. So it didn't have the unit number, but it turns out we got some clarification. I appreciate this. The address is only incorrect on the proof of service, not the notice. So isn't that something that you would think that the process server could update?
Yeah, absolutely. So I don't know if you've attached the proof of service to the lawsuit or not, but the proof of service is just a document to replace the server to having to come to court saying what happened.
Yeah.
So, the process server can absolutely come to court and say, that was a typo. People make mistakes. I went to the right address. Here's the right address with the corrected unit number. I remember that because the person I saw was wearing a pink dress, had sunglasses on, took the notice, and I walked away. So the proof of service is not something that is a requirement. It's more of a convenient document where you may not end up having to bring the person to court to testify. But if the proof of service is wrong, you could just always have the process server come to court and say what they actually did, because some people forget this, but testimony or somebody saying something that happened is evidence. So if I told you that yesterday I had lunch with my wife and I don't give you documents, you would still believe that I had lunch with my wife.
No, I don't believe it for a minute, Kenny. Show me the receipts. Show them.
Some people would believe me. Some people wouldn't. I understand that.
No,
And
I don't believe you because I know her. She's amazing, and she would have lunch with someone else. She's no, I'm just kidding. And then he also clarifies he gave a 60-day notice because the tenant's elderly and it was the holidays. That was in lieu of the 3-day for the nuisance. So, but yeah, and process server, don't they tend to have? Like if I serve the notice for somebody, wouldn't I have to go to court? Because the affidavit doesn't hold as much water for me as a non-process server as it does for a process server. Is that correct?
yeah, so the reason why you want a process server or a sheriff's deputy marshal to actually serve the papers is because it creates what's called a rebuttable presumption. It's codified in the evidence code 647, I believe. And essentially, what that does is that if the court doesn't hear any kind of credible evidence to rebut that statement, you don't need to actually come to court and bring that person in saying that's what happened. The proof of service is enough. Now, is it preferred to always have the person come forward testify about that? Sure, absolutely. But that proof of service with the registered process server gives you that protection that, generally speaking, it was done in accordance with the proof of service. And courts generally give kind of that deference or kind of that idea that if a registered process server is willing to put their license on the line, because these are documents that are filed under penalty of perjury, there's an error of saying, well, they most likely are telling the truth. So that's the reason why you want to use registered process servers.
That's great. We got a thank you from Laker Mark. He appreciates us answering this. And Cam Tony said thank you as well. He did amend it with the complaint. So he should be good to go, it sounds like. Let's see, a few more questions and then a few more things I want to ask you. So we've got someone in the comments who's given us advice on how to avoid Section 8 renters. I don't recommend doing that. For example, pricing the unit higher than the payment standard for housing so the unit will not qualify for Section 8. That still doesn't mean you can say no when someone asks if you take Section 8. And you would be shocked in many cases how much Section 8 will pay. In fact, during COVID, one of the few landlords who actually got paid most of the money were those who had Section 8 renters.
One thing about Section 8 is if you want to try to create a system that will give you applicants that you're looking for, the ones that you do want to rent out to, you could have a system in saying, well, I don't sign year-long leases. I don't sign 3-year-long leases. All I do is
Yeah,
month-to-months.
that's where
And
here that comment's in there as
yeah,
well. Yeah.
so there are some programs that will say we don't provide these services for individuals that are only on month-to-month. So if you're systematic about that approach, that is one way to approach that.
And
Um,
systematic at that approach means everybody who calls in, every one of your renters, whether
Yeah,
they're
so
Section 8
you're
or
not
not.
going to be able to do this. You can't just be like, oh well, I only say that to Section 8 tenants. So
Nope.
that's not okay, and you're not going to get away with that.
Yeah. And it's a double-edged sword in that case too, because don't forget they can give a 30-day notice and be gone.
But
So,
you know what's crazy about that is the month-to-month agreements, to a certain degree, in LA City for now, at least for now,
yeah,
seems to have some weight behind it too, because a lot of these protections don't kick in, up until the tenant is there for 6 months or even a year.
correct. Yeah.
So, if you really don't mind the turnover, honestly, but like, what landlord likes turnover? But leaving that aside, um, you can theoretically just go on a month to month for every single tenant and just say 5 months, get out, see you later, next one.
Yeah. Yeah. But don't forget that the Penal Code 396 has been extended yet again, so you won't be able to charge more than 10%
Oh, that's gonna
to
go on for an eternity.
it's true, it's
It's
true.
you don't even
Okay.
need to tell me that. It's
I
it's
know,
it's
I
already
know.
been extended.
That update wasn't for you. I knew you knew. Tenant already has a fridge. Do I have to buy them a new one? You do if they give you a 30-day notice saying, "Buy me a new one." Yeah. All right. And then Oh boy, there's so many good questions here. This is the thing, like we get rolling and I love hearing all this stuff. And I'm like, how are we gonna fill an hour? And then I look at the clock, I'm like, holy cow, it's already this time. Give me 1 minute of some of the unique challenges for larger real estate portfolios, Kenny, because I know you guys work with property managers, and I know some larger real estate portfolios have property managers, but I know a woman who has 140 doors and manages it herself. Anything unique you can share for larger portfolio owners?
Yeah, so a lot of the laws are actually tailored to, unfortunately, remove out smaller portfolio sizes because the larger portfolios do treat it like a business. But some things that I have seen is that you really have to be clean about your ledger, because there are certain things in there where I'm still seeing people wanting to charge late fees on these ledgers, and they incorporate that into the 3-day notice, and that's a problem. So your ledger is going to be the key that will get you out of almost any kind of issue. And the reason why I'm saying that is that it leads to other foreseeable issues too, where not only can you see if you've been charging late fees that are otherwise impermissible in evictions, you can also see when, where, and how the rent increases occurred, because there are still individuals out there who don't know that they gave a bad rent increase, and that's problematic, not just for small portfolio owners, but large ones as well. Um, but yeah, the ledger being clean is probably going to be the biggest issue, because that's where pretty much everything stems from, and that's how you know how much rent is owed and whether or not it's a correct valuation of what you put on the notice.
And Kenny, this is a trick question, but is a landlord off the hook if their property manager makes a mistake?
No, that's the other thing. It is it's an unfortunate reality where eviction cases, some people may disagree with me, but they move fast. They move fast compared to other lawsuits.
Yeah.
If you ever want to take a look at any lawsuit, the first two numbers will generally tell you the year it's filed, and it's not uncommon for regular civil cases to have a 23 or 22 or
Yeah.
21 next to them.
Yeah.
If you see an eviction case that has a 24 or 23 at this point, something went terribly wrong.
They
Terribly,
didn't
terribly
hire
wrong.
California Property Law Group, I'll tell you that.
And the unfortunate reality is that because you get trial dates so quickly, um, you have to do what's called strict compliance. And that strict compliance is the difficulty that a lot of landlords are struggling with. And I see it where, they're saying, well, if you're doing a nuisance case, they say, well, they haven't paid the rent for X amount of period. It's like, okay, but the notice is what matters. The notice is why we're here. If you want to talk about the rent, we'd have to serve a new notice for that. Which also reminds me that this isn't just this problem isn't specific to just small mom and pop landlords, but I have seen communication issues with property managers because they manage so many different units,
Yeah.
where sometimes they get checks. Let's say that you just get like your monthly checks and you just deposited it in by accident when you're
Oh
in the
no.
middle of an eviction. Well,
Yeah.
guess what? Now you start over, because you're not allowed to accept rent during the lawsuit. You're just not allowed to. And I have seen some property managers do that, and it wasn't because they don't know any better. They know better, but it was an oversight because they're managing too many units or they're just overworked or whatever it may be. So yeah, I mean, even accepting rent during the lawsuit can derail your case. Now, there are ways around that. People make mistakes. You're going to have to return that rent check immediately.
Yeah.
Immediately. But yeah, those are some things that I've seen even large portfolio owners struggle with as well. These
That's
struggles are
great.
not unique. They affect everybody.
Yeah, no, that's great advice. Real fast, Gina's asking if you stop charging an application fee, then you can choose anyone you want. So yeah, so I've kind of blended the process and I'll do a video on it. But if you don't charge an application fee and you collect applications, so first you give them your requirements, then you collect as much information as you can, and you can have 6 applicants. Then you provisionally approve one, and then you have them pay the fee. And if it matches up with their application, you move forward. If it doesn't match up, then you dump them and you don't owe the money back. So it's kind of a hybrid. So that's how I do it. Kenny, why don't I just use AI to file my lawsuit for an unlawful detainer? Like, why do I need you? You guys cost money.
It's so funny that you mentioned AI because we actually, if you take a look at one of our reviews, we did a trial against a defendant in Orange County recently where it was clear he was using AI. Now, the court wasn't going to inquire about how or where he was coming up with his arguments, but the court saw through it and we won that trial. And essentially, AI will give you 80% of the answers. But in a world and in a field where they demand 100%, that 20% may not seem like a lot, but it's an ocean. It's an ocean of difference. You will lose the case off of that 20%. AI can only tell you what you're looking for because it thinks it's giving you answers that you want. But sometimes the reality is you're going to hear answers from us that you don't like, that you have to do more work, that you have to actually look and provide a ledger. You have to give us an accounting of what you did. And AI won't tell you that. AI is going to try to make you feel good about what you're asking. If you ever tell the AI bot it's wrong, the first sentence it'll say is, "You're correct. I'm sorry," because it wants to please you. It wants to give you the answer that you want.
And you don't know if it's wrong to correct it. So that, yeah, you're spot on.
We've moved past the hallucination debacle with cases that AI has already kind of gone through. It's now just trying to tell people what they want to hear in the law. And unfortunately, sometimes the reality is some people put themselves in bad positions and they need to be told how to get out of it. So AI will tell you things to make you feel good. It won't tell you how to get out of your situation. And with us, we try to tell you, upfront and upright what your position is, what your chance of likelihood of success is, because that's going to give you the steps to actually get a result instead of just feeling good about what you're doing.
No, that is great. That is great. And I want to talk about why I always send my business your way, but there's two quick questions before we go. What if the rent amount that a tenant sends is 1% of the monthly rent while you're in the middle of an unlawful detainer? It's any amount of rent, isn't it?
Yep. Yeah, you got to give it back. So, some people say, well, they Zelled me $1.
Yeah. Well, that's the next question. What if they just Zelle or Venmo? That's the argument for not taking these services, using these services for rent, by the way, is that you don't have control over them. But
yeah, you just got to send them a check back and send them a letter saying, I cannot take this money. Here's a check.
Yeah.
That is this best safeguard right away.
Yeah, loyal.
You can also send the Zelle back too.
So look, I have been doing this now. We've been doing live streams for a long time. I've been doing videos for a long time. Been following everything that's going on with landlord-tenant law since COVID started. So now it's over almost 6 years because we're about to get into March. And you guys are honestly the best ones out there for eviction law in all of Southern California. I heard you mention, obviously you work in LA, we know that. I heard you mention Orange County. I'm always pushing you guys to take on additional counties because I know how good you guys are. So don't try to use AI, don't try to do it yourself. Hire California Property Law Group to get the best chance to win. So tonight we ran through a whole bunch of stuff. And maybe some questions you didn't expect, some answers you didn't expect. That's the point of what we're doing. And we appreciate you, Kenny, taking the time to do this. So if you're thinking as a landlord, you're tired of these notices, the processes, compliance, we're here to help with that as well. We've been talking to a lot of landlords who are saying the math doesn't math, and they decide that they want to make a move out of Los Angeles, for example, or Southern California. So reach out to discuss that with us. And Kenny, any last words before we let you go and we see you on a future real estate disclosure episode?
No, I like the name real estate disclosure. It's something that, let's be a little more like California, disclose everything.
That's it.
Just let everybody know what's going on,
And my disclosure for tonight is hire California Property Law Group. Stop doing it yourself. All right. Thanks for being here.